I'm Neelabh Bist, staff correspondent for JURIST in India. Today, it is my great pleasure to talk to Mr. Abhijay Negi, a lawyer and a social activist based in the state of Uttarakhand. Today, we'll be discussing the challenges faced by the Indian legal community during the second wave of the pandemic and how has that shaped and transformed the legal profession in the country. We'll also be talking about Mr. Negi's tryst with environmental litigations in his own home state. So, Mr. Negi, first, let me just welcome you and tell you that it's indeed a great pleasure to have you here with us.
Thank you, Neelabh. A very good afternoon, and it's a great privilege for me to speak to Jurist Legal News. Thank you very much.
So, let me just begin by asking you to tell us a bit about your home state of Uttarakhand.
Yes. So with regard to the geography of India, many people have basic awareness about the city of New Delhi, of course, the capital city of India, and the seat of our Honorable Supreme Court. The state of Uttarakhand is not very far from New Delhi. It is around 200 kilometers towards the north, and it is one of the border states of India. It has China on one side, and it has Nepal on the other side. In fact, there is a lot of cultural linkage between Nepal and Uttarakhand. And the topography, the hills, the mountains, all these facets that the world recognizes about the state of Nepal are also true about the province of Uttarakhand in India. So, of course, India is a huge country. And the most populous state of India, which was the state of Uttar Pradesh, Uttarakhand was the westernmost part of that state until the year 2000. When on 9th November 2000, for the sake of administrative convenience and after a long agitation by the residents of the hilly regions of that erstwhile state of Uttar Pradesh, there was this movement, and then the state of Uttarakhand came into being. So this is pretty much about the state. It's a border state with Nepal and China on the one hand, and it is environmentally very endowed. It is the source of river Ganga. It is from here that the river Ganga takes its shape and then serves the larger interest of humanity before it meets the Bay of Bengal. And it is also the source of a lot of the most sacred shrines of the Hindu faith.
Okay. So now can you just tell us a little more about how Uttarakhand, which you say is a very quiet state in the north of India, how was that affected by the COVID pandemic?
So Uttarakhand was pretty badly affected by the coronavirus. This is because of various reasons. Even though it's a small state, what has to be understood is that, as I shared with you, it has a lot of religious significance for the Hindu faith. In fact, if I could add to my previous answer, the city of Rishikesh, which is very popular as the yoga capital of the world, is one of the cities in the state of Uttarakhand. So with regard to the pandemic, what had happened was that the largest known gathering of human people anywhere on earth, on this planet, called the Kumbh Mela, that takes place once in 12 years, was slated to be held in the holy city of Haridwar in the state of Uttarakhand. Now, if one were to look at the numbers with regard to how the second wave became so ferocious in India, we would note that the Kumbh Mela was scheduled to take place. The Shahi Snans of the Kumbh Mela were scheduled to take place right from 1st of April onwards. And the second wave started really pinching India very badly from somewhere in the mid of April towards the end of April, and took a very bad shape in the first week of May. So one can see with regard to how, because of this Kumbh Mela, even though there were many restrictions put in place by the Honorable High Court of Uttarakhand with regard to certain social distancing norms, a negative RT-PCR as a prerequisite for entering the state of Uttarakhand, a lot of things were done. However, it was not enough, because what had happened was that when there is such a large gathering, and that too in a country like India where religion is very important, it was very difficult to enforce some of these SOPs. And therefore, Uttarakhand sadly became an exporter of the variants of very many variants of the coronavirus. And by virtue of that, the state by itself took a very bad hit. The state of Uttarakhand has around 13 districts. And out of these 13 districts, 10 districts are totally in the hills. 3 districts are either in the plains or partly hills and partly plains. And each of these districts, each of these 10 districts were very badly affected because of a dilapidated state of health infrastructure, because they were in very difficult places and it was not possible for healthcare professionals to reach there. And even among the plain areas, the private healthcare system was totally overwhelmed. People were running around for oxygen. People were running around for the availability of a hospital bed. People were queuing up for cremation grounds. So things were very bad here.
So, Abhijay, just to add to that, uh, you say that it was in a dilapidated state. So if the administration could not help as much, I know that you've been a social activist. So how is it that the NGOs here could really come forward and help when the administration couldn't really help as much?
Yes. So when the administration was completely overwhelmed by the situation, a lot of self-help groups, which comprise ASHA workers. ASHA workers are these village women who are employed by various agencies, state agencies, as well as non-governmental agencies, to go around and spread awareness about maternal health and other aspects in the villages. So they have a kind of an interface with the people of the village. Then many self-help groups are organized by the panchayats of different villages. Cities of Uttarakhand, like the city of Dehradun and Haridwar, as well as Haldwani, these are three big cities in this state. Uh, they are home to many literate people and many literate youngsters, professionals from all walks of life, who pulled in their resources and tried to do their best to help society. And that was possible through pulling in of resources, of ensuring that if anyone can have any contact with regard to availability of hospital beds, they can direct the patient to the right place. Refilling of oxygen cylinders can take place. Logistical support can be provided to the government. There was a time when plasma donation was being encouraged. So they were, see, these self-help groups, including the self-help group I am a part of, our MAD movement, making a difference by being the difference, a group comprising mainly teenagers and students. What we used to do was, whenever we got a lead with regard to someone wanting to donate blood, donate plasma, help with oxygen supply, help with anything, we would make a quick list, notify it after verifying it. Overnight, we used to operate these kinds of helplines to help as many people as we could. And there were many occasions when we terribly failed, but there were some where we were able to save some lives.
So just out of curiosity, I just want to know that did the administration and the government also work in tandem with you, or did they create more obstruction than help?
So I would say that the administration was not particularly obstructive, because they were simply overwhelmed. They were bamboozled by everything. They did not know how to react to that kind of a situation. And therefore, the space was open for non-governmental organizations to come in and do their bit. And if I could refer to a public interest litigation that I had instituted in the Honorable High Court, my petitioner was a social activist by the name Mr. Anu Pant. We had, through that public interest litigation, we had filed an interim relief application before the Honorable High Court of Uttarakhand, which is in a city by the name Nainital, that these self-help groups should be allowed to operate in the state, and they should be allowed to carry out relief operations. Passes should be issued to them by the district administrations. The district administrations of each of the 13 districts should coordinate at a district level, demarcate areas for each of these NGOs. Because what was happening was, say, a family of two people with, both of them are positive, then how would they get their daily supply of rations, of wheat, of flour, of rice, of pulses, of anything? So these were things that non-governmental organizations stepped in, and they tried to help with these supplies.
So it's nice that you brought the working of the code, because I know that I'm made to understand that you are still young in the profession. So can you shed some light on how the pandemic has affected work of young lawyers, particularly, especially in your own home state of Nainital?
It has been pretty bad. It's been quite adverse, because young lawyers particularly, get briefs through any kind of liaising. Often it happens that somebody is frustrated with a big, good lawyer. They are loitering around in the court looking for some hope, and they catch on to a young black coat. That is usually how young lawyers get briefs. And since no physical functioning of court is taking place, and everything has gone virtual, while of course things going virtual can reduce carbon footprint, can have its set of advantages, but I think it was a little too soon for India. The professionals were not prepared to simply be in an interface like we are, to argue virtually, to be at ease with something very new. So it came as a rude shock to many first generation litigators. I am aware some of them have already given up practice because they could not sustain themselves. And those who were able to adapt and were able to quickly take on these briefs, expand their areas of work to maybe other courts, also do a bit of teaching, a bit of legal writing to just sustain themselves. I think they have been able to manage. But it's been a kind of a survival of the fittest story in the law profession, and the pandemic has adversely affected all professions, and law has not been an exception.
But on that, tell me how the big guns, the senior lawyers, how has their work gotten affected by this, or what has exactly happened with them?
So, with regard to the senior lawyers, I would also divide them into two categories. One set of senior lawyers who became tech savvy early, who were able to adjust to the technology interface. I think such senior advocates have not only consolidated their work, they have increased it manifold. For example, I gave you the geographical location of Uttarakhand being only 200 kilometers from Delhi. Now, on a day-to-day basis, it was not possible for some of these top senior advocates to appear in a smaller high court like the High Court of Uttarakhand at Nainital. But the virtual court has made it possible for everyone to do so. So anybody sitting in any corner of not just the country, but the world can appear in any court anywhere. So because of this interface, some of these senior advocates whose services were not hired by clients, who were not able to pay their additional fee apart from their legal fee in with regard to travel, work has concentrated in their pockets, and they are now appearing in across all courts in India, and they are having a good time. In fact, one of the very eminent senior advocates wrote a piece in the Bar and Bench portal, a popular news portal for legal news in India specifically, where he made out a case for virtual courts being the new normal. So while it could be true, but we have to look at it being a level playing field. We have to also appreciate the fact that virtual courtrooms, while indeed it is remarkable for the Honorable Supreme Court and for the Honorable High Courts across the country to have made this shift, but they had the kind of resources. Our trial courts, our district courts, our tribunals are struggling. They are struggling. They never even had the basic office setup. Now everybody expects them to go virtual, and there has been pressure because of the sheer pendency of so many cases in India for these forums to go virtual. And what is happening because of all of this is many of these hearings now take place on the telephone in the lower courts. So they call it audio hearing. So that somewhere takes away the very purpose of a hearing, where you feel that you are not only being heard but seen. Justice is going to be done to you. So these are the various challenges of the judicial infrastructure, and the senior advocates who have been tech savvy have been able to not just consolidate their work, but further build upon it.
But this advantage that you just talked of, senior lawyers have, because right now they were, as you said, their practice was consolidated just to their home state. But now, because of the virtual courts, they can actually go across the country and argue in any other high court or even the Supreme Court. So that is for them. But how is this virtual court system or setting facilitated your practice? Have you also got the chance to argue matters that fall up outside your home state?
So yes, I did get a couple of opportunities outside the state of Uttarakhand. They were incidental. For example, in the state of Uttarakhand, I have a bulk of my litigation categorized as public interest litigation for environmental causes, for the right to health, the right to housing, the right to education. So my work was primarily against the district administration. But there was an interesting matter between the state of Uttarakhand and another border state called the state of Himachal Pradesh. We are two neighboring states. So there was a matter with regard to a question of jurisdiction, wherein the High Court of Himachal Pradesh was exercising jurisdiction over an action of the district administration of the city of Dehradun, which is a city in Uttarakhand, the capital city of Uttarakhand. So I was approached by the district administration to take up the brief at the Himachal High Court, which ordinarily I would not have been able to do. But since everything was virtual, I did take up that brief. And similarly, there were a few matters at the High Courts which we had to give quietus to after the decision of the High Court, because frankly speaking, not everybody can afford the lawyer fees at the Supreme Court. Plus, it is always a trip to Delhi, which is another 200 kilometers from Uttarakhand, and more so for the far off areas of this country. But because of everything going virtual, I feel many matters which ordinarily could never have reached the Honorable Supreme Court because of the sheer logistical hassle were able to reach the Honorable Supreme Court. And many lawyers who had actually argued these cases at the High Court and were in command of the facts of the particular case were able to argue the same at the Supreme Court as well. And I had an opportunity to do so in a few matters. And I feel that it was possible to do so because of the virtual system. Now, while it is true for, I'm sure, for many other young professionals also who've made most of the virtual court system, I just feel with better training to the younger advocates, could have been a more level playing field. I attribute some of the things I could do also to my education, certain things that I had the privilege of, which many who are my age, and I'm sure much brighter than me, much more hardworking, they did not have that level playing field. So I feel if the bar associations or the bar council or these forums could have done a little more to make it more equitable for some of these young lawyers, and if the same situation, the same facilities could have been offered at the district courts where actual litigation really starts, then it could become a more level playing field.
So didn't the district court, high court, or even the bar, didn't they facilitate such a training program for these young lawyers, or in fact, even offer them internet facilities? What all steps did they actually undertake such so as to make it a level playing field?
So there were certain workshops carried out by certain bar associations and by these forums, but it was all very namesake, monotonous, and inaccessible. There was a need to be more proactive to ensure that the young lawyers actually participate. And there is one thing to ensure that young lawyers participate. The other thing is to ensure that judicial forums have the infrastructure. As I shared with you, the concept of audio hearings is taking hold there, which is, I think, a travesty of justice. There should be no audio hearing to decide things because you don't even know if the honorable judge is even listening to you, or if the if the learned advocate is making considered submissions. So these aspects of the judicial infrastructure also at the grassroots have to be improved.
Certainly, Mr. Negi. Also, while we are at this point of virtual courts, what do you think are the major flaws in the working of this virtual courts as opposed to a physical hearing that used to take place before the COVID pandemic struck us?
So I will tell you why I personally feel a virtual courtroom can never replace a real courtroom. What happens in a virtual courtroom is, even with the best of internet, with the most seamless video and audio quality, the very nature of the profession is that it is a very human profession. I am sure many advocates can tell you many stories when the judge has thrown the file. He's called out the next matter. The courtmaster has called out the next matter. But there's one last submission, that one last reminder that changed the fate of the case, where the judge actually goes back to the file and is able to revisit the notion on which he had thrown the file. In the virtual court system, you are just muted the minute the judge has made his first observation or his first action of throwing the file. So I feel that the extra push that the lawyer could give is taken away from him. And what happens in a virtual system is two people can very easily speak at the same time. There could be because of a lag of internet. It could appear to the judge as if that is the lawyer being uncouth or not very respectful. But the only reason is that the internet was the lagging point. And at times, in a virtual setup, it is also open to many lawyers to abuse the process, to just absent from court and then blame the internet. How can the court supervise internet all across the world? That is not possible. And thereafter, also with regard to bulky matters, where there is a lot of filing and you've got to refer to a certain page number, the judge is unable to find the page number. So when a physical courtroom is going on, you can always just show the page number from your own file. You can request the court for its file, open the page number and give it to the judge. All those aspects are lacking. And even clerical help and clerical support, where you have got to do pagination, which requires, when there are so many affidavits filed in a matter that it's running to thousands of pages, then there is a common page number, running page number that's given. Now, if the clerks cannot access the court file, how can there be pagination? So some of these aspects are such that can be remedied, but some of these aspects are such that cannot be remedied. And therefore, I feel a virtual courtroom can at best supplement the system of justice. It can never supplant the value of a physical hearing.
But can you tell me that now that we're talking about virtual hearings, how, according to you, has the approach of judges changed, or how differently have the courts tackled a matter that is brought before them in a virtual setup?
So what usually happens is that I feel judges have become a little more patient in the virtual court. They are more understanding of the fact that a brief is being brought to them in the pandemic, which means there would certainly have been some urgency. The advocate would have worked very hard. So the judges are inclined to give a little more time to the advocate therein. However, on other aspects of a virtual court, I feel that ultimately there is not much more difference, because ultimately the judge is the same, the lawyer is the same, the brief is also mostly the same. So it is mostly adversarial. It's not as if a judge is a yes man. A judge is someone who will ask you the difficult questions, who is likely to not agree with you, and you've got to make that effort. So I feel in virtual courts, drafting has become more important, because judges often read the file more, because they are able to understand that complicated technical issues at times in a virtual system it's difficult to explain. A judge is someone who would ask you an impromptu question whenever he or she pleases. Whereas to ask that impromptu question is easy, but to get a response may be difficult in a virtual courtroom immediately. It We are always at the mercy of the network. So these are some of the differences.
Okay. Also, Mr. Negi, I wanted to just track back to the PIL that you mentioned that you had filed before the Honorable Uttarakhand High Court pertaining to the COVID management issues that were being faced by the state of Uttarakhand. With respect to that, there's an ongoing debate that these COVID-related issues are being taken up by the courts, and there are not many people that who are calling this an unnecessary intervention by the courts, because they're basically stepping into the executive domain. And this is especially because the courts, unlike the executive, aren't really accountable to the people. So what's your take on this?
So the origins of this debate, Neelabh, are not new. It's often been called judicial activism in India. Prominent authors across the world, such as Professor Sandra Fredman, who taught me at the University of Oxford, have written extensively about this, and she calls it dialogic review, where there is a perpetual state of dialogue among the executive, the legislature, and the courts. But what we need to understand here is that this pandemic has set new normals, even with regard to our debate on rights. Usually, what used to happen was, when we spoke about rights, a kind of haloed preference was given to political and economic liberties. In fact, political more than economic. Political rights were given a higher pedestal. Individual liberty was given a higher pedestal. And often issues like health or education, housing, issues which can very easily, with a broad brush, be called socioeconomic. So these issues were given a lesser preference. And often courts would not interfere in these matters, calling it matters of policy. But if one were to actually take the literal interpretation of what we call the right to life, Article 21 of the Constitution of India, the right to life is a provision which says that everyone, no one can be deprived of his right to life and personal liberty. But the very aspect of a life ceases to exist if you don't exist. As simply put, if there are no hospitals, you cannot get medical treatment, what use is the liberty? And therefore, it renders our quest, our legal quest for a more just system, infructuous if we cannot safeguard our right to life. And that is why this has started to change. And courts, when they get this criticism, as you pointed out in your question, was simply trying to safeguard the right to life of every individual citizen who was in a desperate situation. And that is why instead of going to the hospital, they had to come to the courts. Now, if you look at some of the litigation that particularly happened in the Delhi High Court, where hospital after hospital was forced to knock on the doors of the court for oxygen. If the hospitals will not get oxygen, if they are asked to wait indefinitely as patients start succumbing to the lack of oxygen and patients are dying when they could have simply gotten oxygen by a proactive government machinery, which was anyway overwhelmed, sometimes courts help the government to prioritize things better. They shun away the political considerations, they shun away the irrelevant factors and keep the relevant factors before the government, and then prod the government to take the right decision. In fact, that is what is the essence of dialogic review. Courts are logical, governance is experimental. All that is said and done, but there is a situation where politics and governance also has to become logical and cannot be experimental when the life of citizens is involved. And I think courts were very well within their right, including the Uttarakhand High Court, in issuing a slew of these directions to the government.
In fact, very well said, Mr. Negi, that right to life under Article 21 of the Indian Constitution can only be safeguarded once there is life to save. So with that, Mr. Negi, I'll just trouble you with one last question that I have for you. So since the time you've joined the bar, you have been very active with the environment-related issues in your own home state. So could you just give us some examples of the litigations that you've undertaken and the impending dangers that are faced by the ecosystem in your own home state of Uttarakhand?
So Neelabh, I personally feel that even this question of yours is one which has a direct link with all the previous questions that you've asked. I feel it needs to be studied with regard to how the loss of our biodiversity, the plunder of our environmental resources are having an adverse impact on global public health. And there is no better telling of that example than the sad and sorry state of the state of Uttarakhand. The state of Uttarakhand has 70% forest cover. The state of Uttarakhand is the origin of many rivers in the country. And this state is in a very bad shape with regard to its environmental resources because of the lack of sustainable development models. Because everybody wants to just simply urbanize in India. The concept of aesthetically managing your environmental protection, of ensuring that biological hotspots are safeguarded, are not factored into the thinking of our bureaucrats and of the government of the day. So to give you a few illustrations of some of my work, there was a recent collapse of a glacier in Chamoli district of Uttarakhand. In fact, that was quite widely reported because a glacier just came crashing down in the month of February, which is usually a winter month in the state of Uttarakhand. So I had an ongoing public interest litigation that had been initiated by the villagers of that particular area, the Rainy village. In fact, the Rainy village was also the place where a very famous environmental movement by the name Chipko, a simple Google search would give everyone certain details about the Chipko movement, CHIPKO, had started, because the villagers were very conscious about protecting their environment. They had hugged trees. Now, just above that Rainy village, there was this glacial collapse and hundreds of people died in the power projects that were working just below the glacier. And I had a public interest litigation initiated by the villagers of Rainy, who had pointed out the fact that these power projects were doing blasting activity right at the base of the glacier, and environmental harm could be caused. Now, they had a premonition, not that justifiable, but then, sadly so, the litigation had seen a stay order from the Honorable High Court on any use of explosives in 2019. But since our authorities did not take the lessons from the court, in 2021 February, the glacier came crashing down. So I'm currently dealing with that matter. I'm also dealing with another matter where the westernmost habitat of the Asiatic elephant is under stress. The westernmost habitat of the Asiatic elephant is in the state of Uttarakhand, is in a region called the Rajaji National Park. And all these forest areas of Uttarakhand, as I told you, the 70% landmass of Uttarakhand is under forest cover. They have an inter-forest corridor. It's within the forest. And these forest corridors were categorized as an elephant corridor in toto, a huge swath of land cutting across 7 districts of the state of Uttarakhand, hundreds and hundreds of kilometers, was an elephant corridor, which was suddenly denotified by the state government on the pretext of promoting developmental activities, not realizing the fact that the elephant is a long range migratory animal. It is the elephant who connects different jungles, because when the elephant walks, it destroys the vegetation on the way. Fresh vegetation comes in, other animals are able to move in. These finer aspects of environmental conservation are sadly not in the knowledge of our government. So we were able to take a stay order on this denotification of the Shivalik Elephant Reserve, and that is also currently in the knowledge of the Honorable Court. And a few other such matters where encroachment activity is being encouraged on dried riverbeds. It is so convenient to say a river has first dried up because of anthropogenic activities, then going and living in the middle of the river. And then suddenly, when the river comes back to its own course during the heavy monsoon season, we say that there has been a flood, when all the river did was return to its course. So a lot of my litigation is also working on these aspects. And then there are some other aspects, environmental aspects, such as the foothills policy that is there in the state of Uttarakhand. As I shared with you, that this state has a geography where there are plains and there are hills and mountains. So there are certain norms to be followed for hill cutting. Say, construction over a slope of 30 degrees is not ordinarily permitted as per the law, as per the mandate of the building bylaws, which were amended in the state of Uttarakhand in 2015. However, this policy was violated, and that is why we had to press by means of a public interest litigation for a writ of mandamus to stop the violation of the policy, and it has seen some progress. So I feel that since we are so insensitive towards our environment, the environment also pays back in ways we cannot know right now. And that is why it is so important to conserve our biodiversity, to understand and appreciate its impact and its inter-se relationship with public health, and to march forward.
Mr. Negi, also on that, may I just ask you that you talk about these policy issues basically many a times, environmental policy issues that you brought a PIL against. So could you shed a little more light on whether, how, and if whether the approach of courts changed pre-COVID and post-COVID when it came to management of these policy-related PILs?
Oh yes, I think they have really changed pre-COVID and post-COVID. To give you a specific example, I remember in the month of February or March of 2020, when COVID was not at its best in India, I was arguing a public interest litigation matter for better healthcare facilities in the hilly regions of Uttarakhand. And I remember the Honorable Chief Justice, the then Honorable Chief Justice, had given me a proper lecture on how it is best left for the government to decide whether it wants to invest in education or whether it wants to invest in health. It is not for this court to make that choice, young man, is what he told me. And he called it a policy issue. And he said that, it is not for us to tell the state to spend a budget on this particular thing, because that could result in the state not spending that amount of money in another particular thing. A fair point at that point in time. However, after COVID, healthcare public interest litigations are right at the top of the priority of the Honorable High Court of Uttarakhand, as with other high courts, because the pandemic has been so brutal in its equality. it has attacked all sections of society: judges, bureaucrats, politicians, the well off people, the poor people. It's just ravaged every home, either directly by means of making people sick, or indirectly by means of these lockdowns. And this has created a sense of sensitivity among the judicial officers as well, with regard to the fact that health now cannot be regarded as a pushover. Everything else will follow once there is health. And if there is no health, there is nothing. So I have seen in the courts a kind of sensitivity towards health related public interest litigations. And I do hope that with time, public interest litigations are interpreted as non adversarial. They are not, say, against the government. They are for the government to do the right thing, which they should ordinarily have been doing on their own without the intervention of the court, to secure a just society with rule of law. So let's hope that with time we move on that track.
So thank you, Mr. Negi, for your valuable insights. It's really helped gain a lot of perspective coming from a first-hand account of yours. With that, I would just like to thank you again for taking out your valuable time for us. Again, it was indeed a great pleasure to have you here with us.
Thank you, Neelabh. It was wonderful to speak to you, and I wish you and your entire team at Jurist Legal News the very best for everything ahead. Thank you. Bye-bye.
Thanks a lot, Abhijay. Yeah. Wrapping up, this is Neelabh Bist, staff correspondent for Jurist in India. Goodbye.